amendment to the salary, with an amendment with respect to salary to do X.
My understanding is that that would have to be separately noticed and would be considered self-dealing if it was done directly as part of this hearing.
So you're saying that as part of this impasse hearing, with
Correct.
the salary ordinance due tomorrow, we can't vote to give a salary. I want to be clear because we're going to get a legal challenge on that, and if you're right, that's great, and it makes our job a lot easier if you're saying we can't vote a salary increase today.
That's my understanding, is that what is before you is the mayor's proposal, and you don't have to support it. You know, you can vote it down.
If we support 9/10 of it, we can't amend the 10th part, is what you're saying.
You could vote it down, and then I would anticipate that we still have it noticed for closed session in the morning, and you could go back to the mayor and see if there's any movement there or have other discussions with the mayor.
I tell you, somebody said we twisted labor law in the city. I think we're Chubby Checker. I'd ask the DCAA attorney if you could respond to that. Go ahead.
Okay, once again, Margo Feinberg for the DCAA. Well, first of all, it's my understanding that, though we don't think we're at impasse, that impasse has been sent to you, the City Council, to resolve the impasse. To resolve the impasse doesn't mean that you have a choice between A and B. It means that you have to be creative to try to resolve the impasse. That's what the role of an impasse mediator or person resolving impasse is. So I disagree with the city attorney. Obviously, our members oftentimes advise you and would suggest that you normally follow their advice. You're actually not legally obligated to follow the advice of the city attorney. That's your decision to make. I've appeared before many cities in the state of California, and oftentimes council make a decision to do what they think is right. And when this case is right, what's right to do now is for you to act as the body to break the impasse if you can. And to break the impasse, in the case of the firefighters, is to give them what's due them. And for us, we've already made it clear what's also appropriate. Thank you.
I'm going to ask Mr. Betts. Thank you. I'm going to ask Mr. Betts, who the city's hired to advise it on labor law issues, to also respond to that question. Can you tell me, do you agree with the analysis presented by Ms. Yumi?
Well, I agree with Ms. Feinberg that
Mr. Betts is not authorized, and no disrespect to Mr. Betts, Mr. Betts has no authority to give any legal advice to the council. He is retained as a labor negotiator. The people of San Diego elect the person who gives legal advice to the council.
And I'm not asking for legal advice.
No, but I know, but your predicate here, this is out of order. You have no authority to be discussing right now any alternative proposals other than voting up or down as you have been previously advised. As I understand it from the other attorneys, there is no proposal that you can't be negotiating right now and circumventing. I understand that, but what I'm saying is you can't be negotiating right now, and having listened to Mr. Peters, I'm concerned that there is an issue about direct involvement by Mr. Peters in negotiating with members of the representatives of this union prior to
you just
during
make
the
that stuff up. That's not true. You make that stuff up.
Mr. Peters, I don't believe I am making it up based upon what you've been saying, and we'll have an opportunity to secure your records to find out. But are you denying that you had any meetings with the representatives of this union to discuss this issue before today?
I have not discussed the subject of a raise with any firefighter.
Okay.
Ask you once again to support him as we move forward. Thank you.
And I just want to make sure that we understand that we're talking, the last and best final offer is the MEA proposal on pension, the mayor's proposal on health care, and
well, I'm going to give, let Mr. Aguirre finish. I'm going to give the bargaining units their chance to state their legal position if they differ, but let Mr. Aguirre finish his statement.
The MEA proposal, what I'll refer to as the 1.46 pension proposal. I'm just talking about that part of their proposal, just the pension part. The mayor's proposal on medical, and no salary increase. Those are the three essential features that were the last, best, and final offer upon which the proceedings are now before the council.
All right. I'll allow each bargaining unit to state if they have an issue with that characterization. Ms. Smith?
Smith on behalf of the San Diego Municipal Employees
Municipalities Association, we absolutely have an issue with this. Through all the weeks that we were bargaining, in addition to trying to bargain a new MOU, we made a very serious effort to bargain a new impasse procedure. We made a number of proposals. Many of those, all of them, I believe, were shared directly with the City Council so that you would be aware of what we were trying to accomplish in shaping a new impasse procedure. All of our ideas were rejected by the mayor. And we were told that because we could not reach agreement on a new impasse procedure, the current 300-6 would be the prevailing procedure. And we asked for an explanation about how that procedure would work. And we were told that that procedure would work precisely as the city attorney had previously advised. The city attorney had a representative at our bargaining table, and we were told that this impasse hearing would be conducted on the basis that the council would vote up or down the mayor's proposal, his last, best, and final offer. And if it were voted down, then the status quo of the current terms and conditions of our MOU would simply be carried forward into the FY09 year.
The legal opinion is in writing. The fact that someone came here with an expectation or whatever, that's not the procedure that's laid out in the opinion that was confirmed by PERB. The mayor, there's been no change. The mayor has the authority to do what he's doing. The mayor retains the authority from the city's perspective to carry out the collective bargaining. The mayor has made a major concession that wasn't cherry picking. It's now before the council to impose. That's where we are right now.
I also have a comment about the impasse procedures that we believed would be utilized here. Pursuant to Council Policy 300-06, if the city is proposing another last, best, and final offer, that means somewhere between their last, best, and final offer from when we understood it and today, there was some kind of breaking an impasse, which again triggers these other impasse procedures. The mayor didn't jump through those hoops again.
Okay. No.
The impasse procedure that we went through was the one that was for DCAA, the proposal we got on May 7th. For the other unions, it was made and whatnot. So today, the mayor has unilaterally decided, I'm going to make another last best and offer, and now shove it down your throats. And that is a breach of Council Policy 300-06. It's in the policy.
Okay, that's enough. That's enough. Hold on.
So this council has an obligation to follow its own policy, its own rules.
Right.
I mean, otherwise that was an exercise in futility.
No, it was an adjustment.
Mr. Aguirre.
Okay, it was just simply an adjustment to the comments that were made during the course of the proceedings. There were adjustments made. It was the same exact way that most agreements come together. Otherwise, it would never be an agreement. That's all that happened. There's no violation of the policy. The policy was followed clearly. And that's the ruling of the city attorney.
But what is being proposed here is not a memorandum of agreement.
Yeah.
It's a last, best, and final offer.
Now, a half hour ago, we get a new proposal.
No, you can't procedurally do that now. What's before you now is the mayor made a last, best, and final offer based upon the last negotiated point with MEA that was met. That's what's before you. That's what has to be voted, either to impose or not to impose. That's where you are procedurally.
All right. Is there a motion?
Propose the mayor's last, best, and final offer, which is MEA on pension, mayor on medical, no salary increase as to MEA.
So basically, Mr. Aguirre, what you're saying is the pension plan that MEA came in and spoke on 8 hours ago, or whenever we first heard it, would be the and I understand Ms. Smith's comments, notwithstanding it was supposed to be part of a package, but that being separated out, it would be that piece, and then every other part of what the mayor had previously stated as his best and final, last and final offer last week. That would be the action that this council would be taking with respect to MEA.
Correct. That was what was negotiated. That was what was communicated to MEA earlier this evening. Okay.